Okay, I think we are going to get started. Uh, Good morning, good afternoon, good evening, good in the middle of the night, wherever you may be, as is often the case now with virtual conferences. And welcome to the first annual conference on carbon removal law and policy. My name is Will Burns, and I serve as the co-director of the Institute for Carbon Removal Law and Policy at the School of International Service at American University, as well as a visiting professor in the Environmental Policy and Culture program at Northwestern University. And what I want to do at the outset is, first of all, thank a few people who were extremely important in helping to organize this conference, and then to provide very brief framing of the rationale for both the conference and the specific topic that we have today. I will then turn it over to Jenn Brown, our administrative coordinator, for a few housekeeping notes, and then we will move into the first panel. So first of all, a couple of people that I'd like to thank for critical work in terms of organizing this conference. As all of you who have organized conferences know, whether large or small, there are many daunting logistical tasks and many hands who bring together all of the pieces for a conference of this nature. First of all, I'd like to thank my colleague, Jenn Brown, who is the administrative coordinator at the Institute, for all of her help in terms of establishing the web page, outreach, and logistical work today and tomorrow as we proceed through the conference. Second of all, I'd like to thank Molly Williams, who is our technical guru, who will be our point person should we have any difficulties, hoping not, during today and tomorrow. In terms of the actual online presence. And then finally, I'd like to thank Debbie Halla, who is a graduate student in the School of International Service, who has provided a lot of help in terms of outreach to organizations and individuals, and to make them aware of this conference. So, why a conference of this nature? As you know, there are other conferences that now exist on carbon removal, and that is a remarkable thing in many ways, that there are now enough people to have conferences of this nature. If you had talked about that idea a decade ago, when carbon removal was just a twinkle in the eye of many people, that probably would have been a preposterous proposition. But we've obviously reached a point where the world community is increasingly acknowledging that if we are to effectuate the goals of the Paris Climate Agreement of holding temperatures to well below 2 degrees Celsius, or at least aspiring to hold them to 1.5 degrees Celsius, or if in the more likely scenarios at this point, we're seeking to address overshoot situations where temperatures rise above these levels, and we're casting about for ways to help us to bring temperatures back down. We, as a world community, must acknowledge that this will require two components. One is obviously a much more rapid pace of decarbonization of the world economy than what we're seeing at this point. And obviously, the upcoming COP, as well as many national initiatives, are focused on these efforts. However, at the same time, as the fifth assessment report emphasized, and now the working group one of the sixth assessment have emphasized, if we're to meet the goals of the Paris Agreement, or even come near to meeting those goals, we're also going to require carbon dioxide removal. And what makes this particularly daunting is it is not carbon removal perhaps at the fringes, but perhaps a titanic effort to remove carbon from the atmosphere, given the inertia of the system, and given the fact that despite all of the increasing recognition, including the sixth assessment report, of the disastrous consequences of unchecked climate change and the current manifestations of climate change, even at a 1.2 degrees Celsius increase in temperatures from pre-industrial levels, that we're not really decarbonizing, and that increases the exigency for extremely large-scale carbon dioxide removal. Many estimates are that by the end of the century, we are going to have to remove somewhere between 400 to 1,000 gigatons of CO2 from the atmosphere. In the early days, and early days I'm saying maybe even over a decade ago, when we talked about mechanisms for carbon dioxide removal, a lot of the emphasis was on terrestrial options, most notably in the fifth assessment report, in the integrated assessment models, afforestation and reforestation, as well as bioenergy with carbon capture and storage. However, it has become increasingly obvious that as a consequence of technical constraints, as well as sustainability considerations, that we must cast our eyes beyond these options and craft a portfolio of approaches to help us achieve potentially somewhere between 15 to 20 gigatons of carbon dioxide removal ultimately. As a consequence, in more recent years, there's been increasing attention to the potential role of ocean-based approaches to help us meet this goal. In the last couple of years, there's been a proliferation of research that discusses primarily the technical and scientific aspects of these issues. However, concomitantly with this, it will be critical that we address issues of governance, public engagement, notions of equity and justice. Because as I hope this conference will convey today, these are imposing challenges. Many of these approaches will involve direct and fairly active interventions in the global commons, with potential implications in the commons as well as within other countries' exclusive economic zones. And this necessitates frameworks for effectively governing these approaches, acknowledging the trade-offs, potentially establishing means for liability in cases where there are intended or unintended consequences. And the purpose of this conference is to be a modest contribution to framing those issues as the world community moves forward and begins to more actively discuss the potential role of ocean-based approaches in terms of carbon removal. And so I'd like to thank everyone in the audience also for coming to this conference, bringing your expertise and insights, and I encourage active participation as we discuss these issues. As you can see on your screen, I'd also like to acknowledge both the endorsers of this conference, as well as funders of this conference, and helping to make it possible. And so with that, again, welcome. I look forward to the next 2 days, and I will now turn it over to Jenn Brown to talk a little bit about housekeeping, and then we will begin our first session. Jenn?
Hello, everyone. So pleased that everyone could make it today. My name is Jenn Brown. I am the coordinator for the Institute. Just a few quick housekeeping items. First, and perhaps most importantly, is to make sure that you are muted throughout all of the sessions. This is being run as a meeting, so everyone will be able to hear you if there's background noise. The only exception to this is if there's a Q&A session and the moderator chooses to do the hand raise, ask out loud feature. This meeting will be recorded and all the recordings will be made available after the session. And if anyone needs the closed captioning feature, there is an option just on the bottom of the screen. If you click live transcript, you should be able to access that. If you have any technical issues or other questions, please feel free to direct chat me or Molly Williams, who's doing all of our technical support today. And if all your questions, please put into the chat box or any other comments, helpful links, etc. And we will be monitoring the chat pretty closely today. I think that's all for me. Thanks again. Back to you, Will.
Thank you, Jen. Okay, so we are ready to proceed to our first panel of the conference. And so I'd like to introduce the moderator for this panel, which will focus on domestic legal frameworks for ocean carbon dioxide removal. Throughout the conference, we'll emphasize that it is likely that governance of these approaches will happen at several different levels, including the domestic level, more so for some approaches than others, but probably will be pertinent to virtually all of the ocean-based approaches that we could discuss. And so I'm pleased to have a panel with some excellent individuals that have looked at these issues in earnest. And so Romany Webb will moderate this panel. She serves as an associate research scholar for the Sabin Center at Columbia Law School. Romany?
Thanks, Will, and hi, everyone. It's nice to see so many of you here today. As Will said, my name's Romany Webb. I'm a research scholar at Columbia Law School and a senior fellow at the Sabin Center for Climate Change Law. For those of you who might not be familiar with the Sabin Center, we are an academic institute housed within Columbia Law School and closely affiliated with the new Columbia Climate School. We conduct research and host educational programs on various aspects of climate change law, and we have a specific program of work around carbon dioxide removal. We recently published 2 major reports on international and domestic US legal issues associated with ocean alkalinity enhancement and seaweed cultivation for the purposes of carbon dioxide removal. We're working on 2 more reports analyzing international and US legal issues associated with artificial upwelling and downwelling and ocean fertilization, again for carbon removal. And we're very excited to be working with a team of legal academics from around the world to analyze the domestic laws in their respective countries that could apply to those same techniques. So I'm really pleased to have a few members of that international team with me today for our panel. Before I turn over to them, I just wanted to provide a little bit of background and context for the discussion. As Will said, we are focusing specifically on domestic legal frameworks for ocean CDR. And some of you might be wondering why that is. The oceans are a shared resource and there is a large body of international law that governs ocean-based activities. And in previous discussions and writing on ocean CDR governance, a lot of the focus has been on how international agreements and principles of customary international law might apply to different techniques. But as Will alluded to, depending on where those projects occur, they could also be subject to a variety of domestic laws. And so I just want to, just to make sure that everybody's on the same page, talk a little bit about sort of countries' jurisdiction over the oceans. As many of you will already know, coastal countries, those that border the oceans, have some level of authority over areas within 200 nautical miles of their shores. Close all these up. But the extent of that authority sort of varies based on location. And so that's basically what this shows. There's an international agreement called the United Nations Convention on the Law of the Sea, or UNCLOS, which divides ocean areas into several zones and defines countries' authority or jurisdictional rights within those respective zones. So under UNCLOS, each country has what's called a territorial sea, which extends 12 nautical miles from the coast. that territorial sea forms part of the country's sovereign territory. And so the country has, with fairly limited exceptions, full sovereign rights within that area over the water, the submerged land, and the airspace above. Beyond the territorial sea is what's known as the contiguous zone, extends 12 to 24 nautical miles from the coast. That, unlike the territorial sea, that contiguous zone does not form part of the country's sovereign territory, but the country does have certain rights within that area and can exercise control over the area as necessary to implement and enforce its fiscal, sanitary, customs, and immigration laws. Overlapping with the contiguous zone, but extending further offshore to 200 nautical miles from the coast is what's called the Exclusive Economic Zone, or EEZ. Again, does not form part of the sovereign territory of the country, but the country does have certain rights, sovereign rights within that exclusive economic zone, including rights to develop and manage natural resources. It has jurisdiction over artificial islands and other structures. It's responsible for controlling marine scientific research and protecting the marine environment, among other things. Ocean waters that lie beyond the EEZ of any country are considered part of the high seas or international waters. I'm sure many of you already know this, but those waters do not fall under the exclusive jurisdiction or control of any one country, but rather are open to use by all. So UNCLOS recognizes this principle called freedom of the high seas, which basically says that all countries, both coastal and landlocked, have freedom of navigation, freedom of overflight, freedom to construct artificial islands, to engage in marine scientific research, and certain other activities on the high seas. So what does all this mean for ocean CDR, and in particular for the application of domestic law to ocean CDR, which is the subject of our panel today? Well, depending on sort of in which of these areas an ocean CDR project, whether it be research or sort of full-scale deployment, takes place, domestic law might apply to varying degrees. Projects that occur relatively near to shore, certainly within a country's territorial sea, and sometimes also within the exclusive economic zone, will be subject to domestic law. Domestic law could also apply in some circumstances to activities on the high seas, for example, where they're undertaken by nationals of the country or using vessels that are registered or flagged, what's called flagged in the relevant country. Again, as many of you will know, countries' domestic laws are, particularly domestic laws with respect to ocean-based activities, are influenced to varying degrees by international law, and there are several international agreements that are potentially relevant to ocean CDR. One is UNCLOS, which I mentioned before. In addition to defining countries' jurisdiction over the oceans, UNCLOS also includes a number of other provisions that could be relevant to ocean CDR. For example, provisions dealing with marine scientific research that could apply to field trials or other sort of in-ocean research into ocean CDR. Also includes provisions dealing with protection of the marine environment and in particular restrictions on pollution, which could have implications for some ocean CDR techniques, particularly those that involve adding materials to ocean waters, things like ocean fertilization and ocean alkalinity enhancement. Those same approaches could also implicate the London Convention and the protocol to that convention, both of which regulate the dumping of materials into ocean waters. In 2007, the parties to the convention and the protocol, as many of you will know, adopted a decision that said, and I quote, "The scope of work of the London Convention and protocol includes ocean fertilization." And the parties in that statement expressed concern about ocean fertilization. The following year, in 2008, they adopted a resolution which basically said that countries should avoid ocean fertilization with the exception of research activities which could be permitted in certain circumstances. And in 2010, they adopted an assessment framework for to guide assessment of ocean fertilization research. Subsequently, a few years later in 2013, as many of you will know, the parties to the London Protocol, not the convention, but the protocol, adopted an amendment which basically codified that approach. The amendment said that countries could not permit what they classed as marine geoengineering activities if those activities were listed in an annex to the protocol. Currently, that annex only includes ocean fertilization, and there is an exception for ocean fertilization research. And again, there's a framework for assessing research projects to determine whether they should be permitted. There's a number of other international agreements with potential relevance to ocean CDR. One of the ones that gets talked about a lot is the Convention on Biological Diversity, because again, the parties to that instrument have adopted decisions dealing specifically with ocean fertilization and with marine geoengineering more generally.
Yeah, Ro.
We have someone that's unmuted, so I'm just going to ask you to.
I'm glad you're
yourself,
finally taking
please.
charge of getting your own breakfast.
Maybe Jen or Molly, you could mute our audience for us. Thank you. So today's panel is intended to discuss how those various international agreements have been implemented domestically in the US, China, and Germany, and also other domestic laws in those countries that could apply to ocean CDR activities. So we have a really great lineup of speakers who I'm going to introduce them all now. They will each give short presentations, and then we'll have a discussion and Q&A session. If you have questions as we're going through, you can type them in the chat and we'll get to them at the end. And we'll also have an interactive audience Q&A at the end. So our first speaker today, we're going to start here in the US with Korey Silverman-Roati, who is a climate law fellow at the Sabin Center for Climate Change Law, where he focuses on legal issues associated with carbon dioxide removal. Prior to joining the Sabin Center, Korey worked on climate issues at the Institute for Governance and Sustainable Development. After Korey, we'll head to China and hear from Professor Keyuan Zhou and Lei Zhang. Professor Zhou is a distinguished professor of law at Dalian Maritime University in China. He has published extensively in international law, particularly the law of the sea, fisheries management, marine environmental protection, marine security, safety of navigation, joint development, and other topics. And he's joined today by Lei Zhang from Shandong University of Science and Technology. Last but not least, we'll head to Germany to Dr. Alexander Proelss, who is a professor at the University of Hamburg, where he holds the chair in international law of the sea and international environmental law, public international law, and public law. It's quite a mouthful. He previously held the chair in international law and European law at Trier University and served as the director of both the Institute of Environmental Law and the Institute of Legal Policy at Trier University. His research focuses on the international law of the sea, international environmental law, as well as international aspects of German constitutional law. So Korey, over to you.
Thank you very much, Romany. So I will just share my screen. Okay, I think we're all good. So yes, so as Romany mentioned, this presentation is on ocean-based carbon dioxide removal in the US, and we're looking at both legal challenges and opportunities and just giving you a sense of the legal framework for research and deployment in the US. So starting off with the US policy landscape, we've seen in the last couple of years increased interest in funding for carbon dioxide removal and negative emissions technologies in general, and specifically for ocean-based technologies. In fiscal year 2020, we saw increased funding of these technologies up to $60 million to the Department of Energy for negative emissions technologies. $35 million of this is for direct air capture, and then the rest is for the other technologies, which could include ocean-based technologies. And then in the 2021 stimulus bill, we've seen that increase to a potential of $175 million, $60 million of which could go for ocean-based technologies. And in a proposed House bill, the Department of Energy would receive $95 million for all negative emissions technologies. These new outlays are in addition to existing funding programs that may aid carbon dioxide removal technologies. One example is the Department of Energy's Mariner program, which oversees $50 million for the study of macroalgae. And this includes for advanced cultivation, harvesting, and genetic technologies. This funding and interest, this increased funding and interest creates an opportunity for research and deployment, and an upcoming National Academies report this year, specifically on ocean carbon dioxide-based removal, will create an opportunity for even more interest. But in order to take advantage of this interest, we need to take account of the US legal framework. Okay, so in the US, jurisdiction over the oceans is shared among the coastal states, which have primary authority over areas within 3 nautical miles of the shore, and the federal government, which has authority over areas lying beyond state waters within US territory. The Submerged Lands Act of 1953 sets the boundaries of state control at 3 nautical miles from the coastline. And with 2 exceptions, Texas and Florida. In the Gulf of Mexico, the border from Texas and Florida extends 9 nautical miles from the coastline. Now, US waters beyond state control are under the exclusive authority of the US federal government. Within state waters, state owns land underneath the sea, and the federal government retains some regulatory authority. Under the Outer Continental Shelf Lands Act, the federal government also has exclusive authority over the land under the Outer Continental Shelf. And this extends 200 nautical miles out, same as the waters, but in some instances where the physical characteristics of the continental shelf are different, it can extend further up to a maximum of 350 nautical miles. All right, so siting facilities within the US waters, in US federal waters, must take into account of navigation concerns, and both floating and anchored offshore structures require authorization from the US Coast Guard under the Aids to Navigation program. Before issuing such authorization, the Coast Guard must confirm that the structure is appropriately marked and complete any necessary environmental and other reviews. The National Environmental Policy Act, which will come up in a lot of these agency actions and laws that we'll see, requires any federal agency to prepare an environmental impact statement for any major federal action significantly affecting the quality of the human environment. Under the Endangered Species Act, the Coast Guard may be required to consult with the Fish and Wildlife Service before taking any action that may affect terrestrial or freshwater species which have been listed as endangered or threatened. And where the authorized construction will affect land or water use or natural resources in state waters, the relevant state has adopted a management plan under the Coastal Zone Management Act. The Coast Guard must ensure consistency with the state plan. The reviews that I just listed here may apply to other agency action needed for permitting. Okay, so in ocean CDR projects that require use of the seabed, we have a variety of environmental reviews listed here that you're going to need to undertake. And what we're envisioning here are ocean carbon dioxide removal projects that are co-located with things like offshore wind that requires anchoring to the seabed. The Department of Interior's Bureau of Ocean Energy Management, or BOEM, is authorized to lease areas of the Outer Continental Shelf for activities that produce or support energy production or use facilities currently or previously used for oil, gas, and other mineral development. Now, BOEM must comply with the NEPA Endangered Species Act and Coastal Zone Management Act requirements described on the last slide. And BOEM is also required to consult with other agencies to ensure activities do not harm seabirds or marine sanctuary resources. If a place of significant religious significance to American Indians may be affected, BOEM may need to consult with Indian religious practitioners pursuant to the American Indian Religious Freedom Act. Now, once you have a BOEM issued lease, the Army Corps of Engineers permit is required to permanently or temporarily attach a structure to the seabed. Wind turbines and other tall structures may also implicate federal aviation administration regulations. If the FAA determines that the structure may result in obstruction or interference with the navigable airspace, the agency will then conduct a study to determine the extent of the hazard and wind turbines are typically required to meet white paint and synchronized red light requirements. Now, to the extent that any construction is deemed to be engaged in trade, the vessels carrying the construction materials may need to obtain a certificate from the US Coast Guard under the Jones Act, which requires US flagships for trade within US waters. So building infrastructure for these projects might require both investment in the projects themselves and in US flagships capable of carrying supplies out to these projects. Moving on to siting facilities in state waters, coastal states generally require a lease or similar authorization to be obtained prior to construction of any facility that will utilize the seafloor underlying state waters. For example, under California law, a lease must be obtained from the State Lands Commission to use the submerged land underlying state waters. While a great deal of ocean carbon dioxide removal projects might occur in federal waters, seaweed cultivation is likely to occur in state waters, and some other projects associated with other technologies might also occur in state waters. The seaweed projects are in turn likely to require aquaculture permits. Several states, including Alaska, Maine, California, and Connecticut, issue aquaculture permitting that anticipates seaweed cultivation. Several other states' aquaculture permits only anticipate finfish or shellfish operations. So while these states don't explicitly prohibit these activities, permitting might be more difficult in those states. Permits for projects in state waters might also require permits from the Army Corps of Engineers under the Rivers and Harbors Act, where there is placement or removal of structures and modification of the navigable waterway. For CDR projects that discharge, dredge, or fill materials, Clean Water Act permits are required. Several coastal states have established environmental review known as little NEPAs, so very similar requirement to the federal NEPA program. And often if you do a federal NEPA, you do not need an additional little NEPA in the state review. Many states also require permits from the Department of Environmental Protection in the state for construction in sensitive areas such as wetlands. Finally, to add another layer of complication, in some areas, state jurisdiction over coastal waters overlaps with local jurisdiction. In New York, for example, municipal ownership of submerged land overlaps with state ownership, and this creates overlapping state and local permitting processes. All right, for projects that require the discharge of materials into US waters, we have some laws laid out here. Ocean alkalinity enhancement, ocean fertilization, and other projects might involve the discharge of materials into ocean waters, and if so, they may be regulated under the Marine Protection Research and Sanctuaries Act, or the MPRSA. This law was adopted to implement the US's obligations under the London Convention, and it regulates the dumping of all types of materials into ocean waters. And it defines dumping broadly to include the disposition of material. Under the MPRSA, the EPA permits are required where the materials are transported from within the US, the project uses a US vessel, or the dumping occurs within 12 miles of the coast. Any three of these are enough of a hook to implicate the MPRSA. The EPA can only issue permits under this law if it is satisfied that the dumping of materials into ocean waters will not unreasonably degrade or endanger human health, the environment, or the economy. Dumping can only occur within EPA designated dump sites, and there are a limited number of these, and none currently anticipate either ocean alkalinity enhancement or ocean fertilization. So those interested would need to apply for a new site or a new use of an existing site. And then finally, the EPA would also need to undergo the NEPA, Endangered Species Act, and Coastal Zone Management Act reviews described previously. All right, so that covers a broad swath of the legal reviews for activities on the seas. Now here are some related activities on land and some shipping of materials used in ocean alkalinity enhancement. Rock-based ocean alkalinity enhancement will, for example, require the mining and processing of suitable rocks on land, and ocean fertilization may require some mining as well. Ocean alkalinity enhancement performed using electrochemical processes will generate byproducts like hydrochloric acid that will be transported back to land, and that may require some law review as well. All right, the Department of Interior's Bureau of Land Management oversees most mining on federal land under the General Mining Law of 1987, which it confers broad rights to explore for and extract valuable mineral deposits. Before engaging in mining activities, the miner must generally submit an operating plan to the Bureau of Land Management for approval, which must then conduct an environmental review. Each state has its own administrative regime for mineral sales and leasing, but several employ a similar process to the Bureau of Land Management. Some US environmental reviews that may be required for mining are the Clean Air Act, the Clean Water Act, and the Resource Conservation and Recovery Act. And these may impose additional requirements other than the ones previously described. Now, for the shipping of hydrochloric acid, as described, might happen in some ocean alkalinity enhancement projects. The US Coast Guard regulations require ships to be certified and to meet various design requirements. Ships engaged in non-bulk transportation are subject to different requirements, and these are set out in regulations adopted pursuant to the Hazardous Materials Transportation Act. And once the hydrochloric acid reaches shore, it may need to be stored in a temporary storage facility, and facilities handling a large amount of acid, 10,000 pounds or more at any one time, are subject to reporting requirements under the Emergency Planning and Community Right to Know Act. And finally here, a brief discussion here of projects implicating tribal rights. Some carbon removal projects, particularly those impacting fish or fish habitat, may implicate tribal rights. Native American tribes in the US have secured the right to protect their property and way of life, including the right to fish in historical waters through several treaties with the US government. Tribal rights to take fish can create implied duty on the part of state and federal governments to avoid damage to fish habitat. Executive Order 13175 issued in 2000 directs federal agencies to establish processes for meaningful engagement and input by tribal leaders for policies that have tribal implications. And at the state level, the western coastal states of Alaska, Washington, Oregon, and California have each established policies for consultation with Native tribes where state agency activities will affect or significantly affect tribal interests. All right, this concludes a brief overview of the US legal framework. As Romany mentioned in the intro, we have released 2 papers that discuss all of these in further detail on ocean alkalinity enhancement and seaweed cultivation, and then 2 more coming on artificial upwelling and downwelling and ocean fertilization. So something to look out for if you want to read about these issues in more detail. And with that, I will hand it back to Romany.
Thanks, Korey. We're going to head to China now, where it is very late. So we appreciate Lei staying up late to be with us. I'll turn it over to you.
Okay, I will share my screen.
Korey, we might need you to stop sharing. Thanks.
Yeah. Thank you, Romany. Good day, everyone. Although it's already at night in China now. Professor Keyuan and I, we feel very honored to be invited to this meeting. Our presentation is about the legal challenges and opportunities of ocean CDR in China. There are 5 main parts of our presentation. After a short introduction, we will analyze the development potential of ocean CDR in China, then illustrate the implementation of international climate change treaties in China and discuss the key Chinese policies and the laws governing the Ocean CDR project. The final part is a very simple conclusion. And I will do the presentation, and Professor Keyuan will cover the question part. Okay, our presentation is about these 5 kind of ocean CDR technologies: the ocean fertilization, artificial upwelling and downwelling, electrochemical ocean CDR approaches, and seaweed cultivation, ocean alkalinity enhancement. According to the International Energy Agency report, the majority of the world's CO2 emission reductions under a 1.5 to 2 degrees centigrade scenario must be realized in developing countries. As a result, the Paris Agreement achieved a universal agreement on the intended nationally determined contributions, the INDCs. And that means both the developed and the developing countries should together take necessary action to fulfill the target. China has submitted the INDCs and promised to reach a peak in carbon emissions by 2030 and be carbon neutral by 2060. In order to meet the commitment and balance the goals of energy security and environmental stability, sustainability, the ocean CDR technologies can no doubt help China achieve this goal. But considering the manufacturers, not all the ocean CDR technologies are popularly acceptable or implementable in China. The development of the 5 ocean CDR technologies can be divided into 3 categories: in priority, in experiment, and in action. The first one is the seaweed cultivation. This one seems the most popular approach out of the 5 ocean CDR technologies in China. China accounts for about 70% of the global seaweed aquaculture. The large commercial algae are abundant in China. A recent assessment reported that there are 27 nations, including China, have included blue carbon mitigation contributions in their NDCs. So in encompassing the protection, replantation, or management of seaweed, the seagrass, mangroves, salt marshes, there are several programs related to seaweed cultivation that have been conducted in Hebei, Guangdong, and the Shandong provinces. At present, the sea area for large-scale seaweed cultivation only accounts for 0.3% of the coastal waters in China. So there is still huge potential and room for the further development. The second degree is in the experiment, that is the artificial upwelling. This one in China, Zhejiang University has been studying the technical details of the artificial upwelling for a long time. The university have already undertaken outdoor experiments in Aoshan Bay, located in Bohai, Shandong province. Well, different from the seaweed cultivation and artificial upwelling, the ocean fertilization, alkalinity enhancement, and the electrochemical ocean CDR approaches are not yet carried out in China at present. And China has already joined the UNFCCC, the Kyoto Protocol, and also the Paris Agreement. As a non-Annex 1 country of the UNFCCC, China does not undertake qualified greenhouse gas reduction obligations, but based on the principle of common but differentiated responsibilities, China has undertaken some international obligations which are embodied in the general commitments set out in Article 4 of the UNFCCC. And as a party of the Paris Agreement, China has nationally determined its actions by 2030, as shown in this slide. In order to implement these climate change treaties, China has made or updated domestic policies, laws, and regulations in these three aspects. For the first one is for the policies. Since the 1980s, China has developed and implemented a series of comprehensive sustainable development policies, climate change policies, as well as the financial tax incentives for energy saving projects, and promulgated a series of energy plans. For the laws and regulations, in order to promote energy conservation and improve the energy structure, as well as promote the development of renewable energy sources, there are some laws and regulations adopted in China, such as the law on prevention and the control of air pollution, the clean production promotion law, and so on. And recalling the Articles 4 and 12 of the UNFCCC, each party shall submit its national communication. China has fulfilled this responsibility and submitted the relevant reports. The information of China's national mitigation actions, the funds, technology, and capacity building, and also other informations are included in these reports, which presenting a full picture of China's national efforts on addressing climate change. Well, there are other policies and at the national level relating to ocean CDR, such as the 13th 5-year plan, the 14th, and the Blue Book on climate change in China. For example, in the 13th 5-year plan, illustrates the importance of the implementation of the mangrove in south and Tamarixi in north wetland restoration, which plays an important role in CO2 removal. All these projects listed restoration of coastal vegetation as a national priority. Well, the existing policies focus more on terrestrial CDR projects, such as the land-based carbon removal, forest carbon sinks, rather than the ocean CDR. As for the linkage between the ocean and climate change, the existing policies pay more attention to coastal restoration, mangrove conservation, and the projects related to the seaweed cultivation. The application of all the ocean CDR technologies in areas within China's jurisdiction should abide by relevant Chinese laws. At present, there is no commercial project of ocean CDR in China's jurisdictional waters, nor ocean CDR specific law to provide the oversight of ocean CDR projects. But some existing laws are applicable, covering parts of the ocean CDR projects at least, such as the first one is adequate. The marine scientific research is necessary for the ocean CDR project. To ensure the implementation of marine scientific research, China has promulgated a number of laws, such as the regulations on the administration of foreign-related marine scientific research. And the 5 ocean CDR projects could, in some circumstances, require the use of seabed to seed facilities, just as Korey mentioned that. As all the projects might have impacts on the marine environment, the application of which should abide by the Marine Environmental Protection Law, we use the MEPL for short, and the marine engineering regulations. Besides that, the ocean alkalinity enhancement and other CDR projects involve discharging materials into the ocean. There is a global framework concerning prevention and the control of dumping wastes at sea. That is the London Convention and the London Protocol. China is also a party to both treaties. In order to implement them, China implemented necessary domestic measures, including the adoption of relevant domestic laws and regulations, such as the MEPL, the dumping regulations, the measures for the implementation of the dumping regulations. There are other related activities, such as the mining. Rock-based ocean alkalinity enhancement will require the mining of suitable rocks on the land. The electrochemical processes of some ocean CDR technologies will generate byproducts that will be transported back to land. So the relevant laws are applicable to these kind of activities, such as the mineral resources law, rules for classification and the labeling of commonly used hazardous chemicals. Here is the simple conclusion. Okay. Not all the ocean CDR technologies are popular in China, and there are no comprehensive national plan or the ocean CDR specific laws and regulations to provide the oversight of this project in China. But some existing laws are applicable across parts of the projects. Well, if the ocean CDR projects move to fully scale commercialization in China in the future, there are more complicated legal issues to be considered. So this is our presentation, and thank you for your listening.
Thanks so much. We're going to go last but not least to Germany, to Alexander.
Thank you very much, Romany. Let me just share my screen with you. Excuse me, you should be able to see it now. Is that correct? Can just
yes, we have it.
Great, thank you very much. And let me start by saying hi to all of you and extend my gratitude and thanks to the organizers of this conference in general and this session in particular. It's greatly appreciated. Now, what is the structure of my brief talk, which I'm going to give now? Make some introductory remarks and give you some information on the background, then take a look at a specific case of implementation of international law in Germany, namely how Germany has implemented within its domestic legal system the London Protocol amendments of 2013, which I assume is quite interesting maybe for this audience, because Germany has already initiated relevant legislation. Taking a closer look then at the regulatory approach that Germany has taken in comparison to the approach on which the London Protocol amendments are based, then take a closer look at ocean-based CDR under the relevant German piece of legislation, which is called the High Seas Dumping Act, and then end with a couple of remarks concerning specific issues and some legal uncertainties, as I would call it. Now, let me also start with some remarks on research that has been conducted within Germany on CDR, but also on climate engineering in general, including radiation management. The largest of these interdisciplinary projects, which I'm referring to here on the slide, was funded by the German Research Foundation and included a priority program concerning climate engineering risks, challenges, and opportunities, which ran from 2013 to 2019. It's important for me to say that this research did not include any field experience concerning any of the activities that we are discussing at this conference. There is, and I saw the logo already on Will Burns' introductory slide, a European-wide also interdisciplinary research consortium funded by the EU Commission called OceanNets, which essentially and specifically focuses on ocean-based negative emissions technologies. That also includes a sub-project concerning the legal situation, but not domestic law, but rather the international level, some specific questions such as attribution of private conduct to states parties to the agreement that Romany already mentioned. And right now, first decisions have been taken by the Federal Ministry for Education and Research concerning a couple of projects that involve different carbon dioxide removal technologies. let me then start with some introductory remarks concerning Germany's participation in the relevant international legal agreements. Germany is a party to the Law of the Sea Convention, to the London Protocol, as well as the Convention on Biological Diversity. And once these treaties have been ratified by Germany under German constitutional law, they have become part of federal law and must thus be respected by the executive and the judiciary in accordance of what we call the principle of strict obligation to justice and law, which essentially is something similar to the rule of law. What about the maritime zones then that Romany introduced the audience to at the beginning of our talk? Now, Germany has only delineated its territorial sea and the exclusive economic zone in 1994. That is the year when Germany became party to the United Nations Convention on the Law of the Sea. As many of you, in particular those familiar with general public international law, will know, the developments concerning the continental shelf started much earlier and culminated in the famous North Sea continental shelf cases before the International Court of Justice. In the meantime, the continental shelves of Germany and its neighboring states in the North Sea have been delimited by way of bilateral delimitation agreements. Let me then now take a closer look at the 1996 London Protocol, which is, I would say, the most relevant international treaty that has a word to say concerning ocean-based carbon dioxide removal. Now, the Law of the Sea Convention itself contains a provision in its Part 12, referred to by Romany, that has been substantiated by the London Protocol. And I'm mentioning this here for a specific purpose, because this very provision of the Law of the Sea Convention contains what is called a renvoi, a reference to, and I quote here, global rules and standards, end quote. And these global rules and standards are indeed codified in the London Convention, and according to most observers, also in the London Protocol, notwithstanding the fact that the protocol only entered into force after the United Nations Convention on the Law of the Sea entered into force. And this leads to a particular legal consequence, namely that states parties to the Law of the Sea Convention are indirectly bound in terms of minimum standards to the standards contained in the London Convention and Protocol, provided that they have been entered into force. So it is not necessary for the states concerned to have ratified the London Protocol once they have ratified the Law of the Sea Convention. And I feel that this is a legal consequence of the regulatory approach taken by the UNCLOS that not every state was perfectly aware of when the states concerned decided to ratify this agreement. Now, most importantly, of course, and this is what I'm going to focus on as far as German implementation is concerned in the minutes to come, the 2013 amendment to the London Protocol regulating what is called marine geoengineering, which has not yet entered into force, however. Now, how has that been implemented? And let me once again emphasize the international legal framework concerning marine geoengineering, which was included in the London Protocol, has not entered into force, but Germany has taken the decision not only to ratify the very amendment, but also to already at this stage implement it within the domestic legal system prior to the entry into force of the relevant act on the international level. And that has been done in particular by amending two legislative acts on the federal level. The first one being the Federal Act on the Prohibition of the Dumping of Waste and Other Substances and Objects into the High Seas, which I will call the High Seas Dumping Act in the minutes to come, and secondly, the Federal Water Management Act. All this has been done by a legislative act on the, as it is called, restriction of marine geoengineering. And I'm emphasizing this here because the focus within German law on how to deal with what is called marine geoengineering, I'm going to make a couple of comments on that in a minute to come, has been on restricting it and not fostering it. Now, this obviously is a political decision, which is perfectly legitimate, but it's important to know this in order to understand the German legal system as it stands for now. let me start with the other act, the Water Management Act. Now, this is the act by which Germany has transposed European Union acts into its national law, namely the Water Framework Directive on the one hand, and the Marine Strategy Framework Directive on the other. And this Water Management Act is applicable to both coastal waters and marine waters. But with regard to marine waters, which is the category perhaps even more important here, it does not establish standards concerning individual ocean-based activities which involve the introduction of substances into the sea. So the other legislative act is the more important one. And there we go, the High Seas Dumping Act. And that is exactly the legislative act which serves to implement the London Protocol in relation to the German EEZ and the high seas. Now, what about then the internal waters and the territorial sea? Well, that is covered by the other act, which I mentioned, the Water Management Act. But interestingly, that very act has been amended by a renvoi, a reference to the High Seas Dumping Act. So ultimately, the relevant standards with regard to marine geoengineering, at least, are codified solely in the High Seas Dumping Act. Now, don't get me wrong. These are not the only legislative acts under German law that have a word to say concerning ocean-based CDR. There's a couple of other ones, thinking of the Maritime Facilities Act, thinking of course, the Federal Act for Nature Conservation. But I'm focusing on this very High Seas Dumping Act here because it is the one by which Germany has indeed implemented the London Protocol Amendment into domestic law. Let us take a look then at the regulatory approach, and just by way of comparison between the approach on which the London Protocol is based and the High Seas Dumping Act. And what you can see here is that Germany even further restricted dumping, including, as I will show, marine geoengineering activities in its domestic legal system. While the London Protocol was based on the idea that the dumping of wastes or other matter is generally prohibited, with the exception of those matters listed in Annex 1, which may thus lawfully be dumped, provided that a permit has been granted. This is not the case within Germany, but rather the High Seas Dumping Act prescribes a general prohibition of matter, no matter what category, with some small exceptions, which are then prescribed in this act. And I will get back to that in a minute. So my main message here is the High Seas Dumping Act is even stricter concerning the establishment of limitations concerning the lawfulness of dumping than the London Protocol is. Let's focus then on ocean-based CDR. Now, if we apply this High Seas Dumping Act, which is applicable, by the way, I should have said that before, in terms of its geographical scope and the German EEZ on the high seas, but also on German flag ships in the EEZs of other states, whether or not ocean-based activity aimed at CDR can lawfully be conducted, thus depends on two conditions. The first one is, do these activities constitute dumping, or are they related to the dumping of substances? That's the first one. Secondly, in the affirmative, are they covered by one of the exceptions to the general prohibition of dumping under this legislative act? If not, it's prohibited, full stop. What has happened then in 2018? The High Seas Dumping Act was amended, and provisions concerning marine geoengineering, in more or less at least implementing the 2013 amendment to the London Protocol, were included in this act. And that refers first to the definition of dumping, which was amended to number 5, and I quote, the introduction of substances and materials into the high seas in the context of marine geoengineering, end quote. And if the act speaks of high seas here, this always covers also the EEZ. Please keep that in mind. Now, then there's an exception to this definition of dumping, which is relevant for ocean-based CDR, stating that such dumping does not occur if, I quote, nature conservation measures are carried out or ordered by the competent authority or carried out by third parties with its consent, end quote. So there's a difference, obviously, between marine geoengineering on the one hand and nature conservation activities on the other. That is important with regard to blue carbon activities, because we need to distinguish them and delimitate them in accordance with these categories. I'll get back to that in a minute. Then this German Act contains a definition of marine geoengineering. Speaking of, this is just a summary, targeted interventions that may have adverse effects on the environment or on human health. And most of them being intended to counteract human-induced climate change or its effects. And once again, some projects are excluded from the definition of marine geoengineering, namely conventional aquaculture and mariculture, and secondly, the creation of artificial reefs. Thirdly, also the rules concerning exceptions to the prohibition of dumping were amended, namely with regard to substances and materials introduced as part of marine geoengineering measures. Now, this does not mean, however, that these substances in the context of marine geoengineering may indeed be introduced into the marine environment, but rather that exception then moves on to state that only those can be exempted from this prohibition which are listed in the annex to the Act. And so far, in accordance with the international legal situation, only activities aimed at stimulating primary production in the sea conducted for scientific research purposes have been listed in this annex. Just a quick note at the approval procedure. Now, once again, this only covers those marine geoengineering activities that have been listed in the annex to the Act. Okay, so far, only ocean iron fertilization. Those activities require an official permission. This permission must be rejected if there's a risk of pollution of the marine environment, which cannot be prevented or compensated for, which is, I would argue, then a reference to nature conservation law. Secondly, the permission must also refuse if it cannot be ensured that the operator complies with specific obligations that have been included in this Act applicable to marine geoengineering. And when it comes to geoengineering research, these obligations essentially correspond to the international requirements contained in Annex 5 of the London Protocol. So there's a very close relationship between the London Protocol Amendment and the German Act. Finally, some remarks on specific issues which I could imagine are interesting for the audience. The question is, based on what I said so far, whether ocean-based carbon dioxide removal can actually be considered as disposal or introduction. If not, the High Seas Dumping Act is not even applicable. Okay. Now, if we then take a closer look at what disposal and introduction mean, it is fair to say that ocean-based CDR is no disposal because it lacks the element of a subjective purpose, namely the intent to dispose the substance permanently. Conducting CDR serves a different purpose, namely to counteract human-induced climate change. So disposal, I would argue, is difficult to justify here. But what about then the introduction of substances? Well, most ocean-based carbon dioxide removal activities are indeed based on substances, but are they also introduced into the marine environment? In most instances, yes. But I think there is a couple of categories where this is at least questionable, and that refers to artificial upwelling and downwelling. Why? Because no extra substances are introduced into the marine environment when conducting these activities, of course, with the exception of the installations, which is a different matter, but rather substances which are already existing in the marine environment are simply used in order to enhance the biological pump. And I would say that this does not suffice to act on the assumption that substances are introduced into the marine environment. And I would maybe more questionable argue that the same applies to microcosm experiments, under the condition, however, that these experiments are conducted in closed containers and the water that is used is, after the experiment has been conducted, then taken away from the marine environment. Let me skip this. Now, what about blue carbon development such as seaweed cultivation then? Is that an introduction of substances into the marine environment, or is it even marine geoengineering? Well, as I tried to highlight before, the High Seas Dumping Act contains an exception for nature conservation measures. And I would argue that it is depending on the circumstances of the individual case, possible to argue that blue carbon development, such as seaweed cultivation or the cultivation of sea grasses, is actually such a conservation measure. Now, obviously, this very much depends on whether or not the activity concerned complies with the legal requirements of nature conservation law. If not, that's the end of the story. If yes, I would argue, why not? Because the High Seas Dumping Act itself shows that not every intervention into the marine environment that influences natural processes is actually marine geoengineering, but only those activities are that, and I quote once again, may have adverse effects on the environment or on human health, end quote. Final point, what about the other ocean-based CDR activities then? And I'm thinking here about ocean iron fertilization, about electrochemical approaches, and in particular also ocean alkalinity enhancement. Well, here there cannot be any doubt that an introduction of substances into the marine environment takes place. I would find it very difficult to argue that these activities are nature conservation measures, and taking into account that so far only marine fertilization conducted for scientific purposes has been listed in the annex to the High Seas Dumping Act, the other activities at this moment of time cannot be authorized. But of course, it would be possible to amend the list in the annex by the German federal legislator, which I would assume is likely going to happen if the list on the international level, the one annexed to the London Protocol, is amended accordingly. And with that, I'll make a full stop here. Thanks very much for your kind attention. Happy to answer any potential questions. Thank you.
Great, thanks to all of our speakers for a really interesting discussion. We have some time now for Q&A and discussion. I see a few people have already put questions in the chat. If you have questions, you can place them there, or you can use the raise hand function and I will call on people. I'm going to use my moderator's prerogative and kick us off with a question for Alexander, actually. You noted that Germany has really gone beyond the requirements of the international legal framework. It is one of the few countries, I think there's 6 countries that have ratified the 2013 amendment to the protocol, and it has even implemented that amendment even in domestic law, even though it has not yet taken effect internationally. Why do you think it is? Can you give us a sense of why Germany has been so proactive on this particular issue, whereas other countries have been much less active?
Thanks for that, Romany. Well, I think the answer is not that easy to give. What should be remembered here is that Germany was confronted with marine geoengineering issues at a comparatively early stage of development, namely in the context of the so-called low-half-hex experiment, which was a comparatively large-scale ocean iron fertilization experiment conducted by a joint German-Indian consortium. This very experiment was extremely controversial within the German political landscape, and it clearly influenced the development of international legal requirements, both within the context of the Convention on Biological Diversity, as well as within the context of the London Protocol. So I would assume that Germany understands itself as one of the forerunners in the regulation of climate engineering in general, and marine and geoengineering in particular. And that could well be one of the reasons why Germany did this kind of implementation at a very early stage of development. Also keep in mind that Germany was one of the states that sponsored the 2013 amendment to the London Protocol. So I assume that it was simply felt that, well, if we sponsor it, if we were part of the group of states that came up with this kind of amendment to an international agreement, we simply also need to take things serious and then implement it on the domestic legal level. That would be my answer to that.
Great, thank you. That's a nice segue to another question I have for all of our panelists around issues around sort of social acceptance and social license for ocean CDR, because we have seen in these previous experiments that have occurred a real level of social concern and social opposition in many cases to these projects. So social license issues are I think, going to be really important as we think about scaling up, as we think about doing further research, and then if we do sort of scale up those technologies. So it's really, I think, important that sort of communities and other stakeholders be involved in decision-making around some of these approaches. Can you each just say a few words about how, whether and how existing domestic legal frameworks facilitate that sort of community engagement, knowledge sharing, sort of public participation in permitting and other decision-making around ocean CDR? China, why don't we start with you? Keyuan?
Thank you, Romany, for your kind of question. And the simple answer is no. There's no kind of social licensing now in China, because but in terms of the broader framework of mitigation of emissions and also the climate change, and there's a kind of participation, public participation existing. And that's one thing I would like to draw attention of the audience is China, unlike the United States, China is a unitary country, and there's no divide between the divide of the legislative power between the central level and the provincial level, and the central level only follow if they can adopt the local regulations, the local laws, but they must follow the central legislation. And the highest legislator in China is the National People's Congress, which is just like the Congress in the United States. So this is one thing. The second thing is, unlike the United States, China is a party to the UNCLOS. So China declared its territorial waters and EEZs and continental shelf in accordance with the UNCLOS, with that convention. But of course, because China, unlike the geographically speaking, China is unlike the United States, it has very broad sea area. China is a relatively disadvantaged country in terms of the maritime zones, because China is situated in the semi-enclosed seas, and all these semi-enclosed seas, and China has maritime delimitation issues between the neighboring countries. So the maritime zone, there are a lot of disputes. If you look at the mass media, there's a lot of disputes existing in the South China Sea, East China Sea. And so the problem for the ocean CDR, if we look at whether there's a very clear-cut delineation of the maritime zones of China, the picture is not very clear because of the overlapping claimed maritime zones between China and its neighboring countries.
Yeah,
Lei, would you like to add something?
No.
Great, thanks. Yeah, there's an added level of complexity when we have these inter-country disputes. Korey, do you want to say a few words about sort of the arrangements for knowledge sharing and stakeholder inclusion in the US context?
Yeah, so I think existing US environmental law provides some opportunity for engagement and knowledge sharing and stakeholder engagement with notice and comment processes, with engagement with like NEPA processes, but the lack of an overarching domestic US framework, I think, is a challenge for building the social license for these projects. Obviously, there's a lot of federal interest, as I discussed in the increased funding the last couple of years for research into these projects, but there's not sort of this one dominant agency that a interested party would go to try to like streamline the permitting processes that would sort of establish that consultation process. And I think you see that sort of in the US's approach to tribal consultation, where agencies are directed to consult with tribes on issues where they're going to significantly affect tribal interests, but there's no sort of like central process where every single one of these projects is going to get an engaged consultation with a tribe that might be affected. So I think that the people can get lost in sort of the Byzantine various regulatory processes that they have to go through.
Yeah, it's certainly a complex process to navigate, particularly for groups and individuals that don't have significant resources or experience with the process. Alexander, what about in Germany?
Well, under the legislative act, which I focus on, the High Seas Dumping Act, there are indeed legal obligations concerning public information and consultation. That's one of the permit requirements, actually, that need to be fulfilled by the operator. These steps need to be taken before the permit is, before a decision on the permit is done, and it is controlled actually by the Federal Environment Agency, which is the body under federal law that has been allocated the power to deal with these kinds of permits in the context of marine geoengineering, however. So with regard to other activities that do not fall within this definition, it is a different federal authority competent for this. But when it comes to science, I can tell you that all of the larger research consortia, which I mentioned at the beginning of my talk, have created extra work packages that try to initiate stakeholder dialogue and participation, but this obviously is not accordance to a formal law, but rather more a self-given governance structure.
Great, thank you. We have a question from Will. Do you want to unmute yourself and ask?
Yeah, thanks. Great presentations, everybody. Thank you very much. This question is for Alexander. I noticed you had a bullet on one of your slides that you probably just didn't get to in the interest of time, but I was really interested in, which is the question of whether German legislation incorporates the express exception to dumping that's set forth in the convention, right? Purposes for other than mere disposal. Do you have any thoughts on that?
Correct, Will. That's exactly the slide I skipped because I thought this would potentially go too far, and I was, kind of stretching the time limit already. Wonderful question. Thanks for that. Well, it's interesting to note that the German legislator did not implement that very exception to the definition of dumping into the German law. The question is, however, does it still apply? I think there's a good case to argue that it does. And we have a precedent decided by the Federal Administrative Court of Germany saying that the introduction of large stones conducted by a private NGO, namely Greenpeace, but so to say, creating an artificial reef was not going to be considered as dumping because a purpose different than the mere disposal thereof was pursued with that very activity. Now, the problem is that this decision stems from a time prior to the amendment of the German High Seas Dumping Act. So there's a lot of legal uncertainty whether it would still apply. My personal opinion is that it is still possible to interpret the German Act in line with the London Protocol, but that's a matter for debate, and there are other observers that do not take that position. Thanks, Bill.
Thank you.
We have quite a few questions in the chat, and if other people want to ask questions of our panelists, please raise your hand. One question from Liz Bridgewater at WRI asks what the sort of key legal barriers are in the US for particularly scaling up ocean CDR. I would broaden that and say, what are the key legal barriers in each of your countries? I think, Alexander, you've already sort of talked about this in the context of activities that are classed as marine geoengineering, but perhaps activities that you could speak a little to activities that don't fall within that definition. But Korey, since it was a US focused question, why don't we start with you? What do you see as the key legal barriers? And I'll expand it to both ocean CDR research and to ultimate scale up if and when that occurs.
Yeah, so I think as I showed in the presentation, there's key distinctions in US law between those projects that make use of the seabed and those that do not. And I think there are considerably more barriers to projects that are going to make use of the seabed. and significantly higher permitting requirements and laws that you're going to have to go through. But within the framework without using, like attaching a structure to the seabed, there might be relatively few barriers if you're in US waters and you're far out. If you're within state waters, the barriers are going to come in sort of overlapping state and federal jurisdiction, overlapping state and local jurisdiction, and figuring out which agencies you're going to have to go through to get these projects permitted. And then there can be time barriers with NEPA processes. An environmental impact statement can take a considerable amount of time if it's deemed to be a major agency action significantly affecting the environment. So this is sort of just a brief overview of the barriers, but I don't know if you had anything to add there, Romany.
Yeah, I think there are certainly, in a lot of cases, a lot of hoops for both researchers and developers to jump through, and it can be very difficult to navigate that process, time-consuming, costly, etc., which is a real issue. What about Team China? What do you see as the key barriers?
The key barriers, I think, just I mentioned the kind of overlapping maritime zones existing in the semi-enclosed seas and adjacent to China. And the second thing is, and maybe it's a kind of insufficient governing laws and regulations available. Now, this is another key barrier in China because that's because it is in terms of the ocean CDR, it is not yet commercialized in China, except for the seaweed cultivation. But seaweed cultivation is not for the purpose of climate change, but for the purpose of seafood served to the dinner table in China, and it is treated as a kind of seafood in China. So it's a quite different purpose, and the farmers they grow up the seaweed in the coastal waters. So it is the third thing is, I think, because the ocean CDR is kind of emerging industry in China. I think China is a kind of newcomer and then need to learn a lot from the United States and Germany, and for the future. Thank you.
Thanks. And Alexander, did you want to add anything about barriers in Germany?
Well, when it comes to the regulation of CDR, I'd really say the most relevant barriers are those that arise from environmental and nature conservation thinking, which is completely legitimate. Once again, this is a political decision, right? That governments and societies have to come up with. At the same time, I would argue that there is somewhat increasing pressure on making the regime a little more flexible in light of the fact that be it the IPCC, be it the UNEP, be it other actors, seem to agree in the meantime that in order for it to be able to achieve the climate targets, there need to be some kind of supporting CDR activity. So it's going to be interesting how this will affect the debate within Germany.
Yeah, it seems that Germany has taken a very sort of precautionary approach to some of these principles, which is sort of leads me to another question that Brad Warren has posed in the chat around whether other countries whether the existing laws in other countries are sort of sufficiently protective. I think, in both China and the US, there is no sort of dedicated law specific to ocean CDR, which is the point you both made. Are those existing laws that are applying to ocean CDR sort of sufficiently protective? Do they have sufficient safeguards against the potential sort of negative outcomes of ocean CDR, in your opinion? Team China, you want to weigh in on that?
Because just I mentioned that China is a relatively newcomer, and there's no specific laws and regulations governing the CDRs, and possibly in the near future, and there will be some come into place, but not yet now.
Okay, Korey, what do you think about the adequacy of the existing framework?
I think you see in US federal waters, a lot of the laws anticipate the use of the waters for oil and gas development and sort of don't necessarily anticipate the use of carbon dioxide removal projects. So I think you could see gaps within the framework where environmental harms might sneak through, where the laws might not necessarily anticipate them or cover them. And I think another maybe missing aspect within US law is an ability within the framework to distinguish between legitimate scientific research and illegitimate scientific research, something that the London Convention and Protocol pointed out in the amendment, in the resolution on geoengineering. So a framework within US law to distinguish between those two types of projects might be important and help protect against scientific projects that maybe don't have the same scientific legitimacy that other projects may help advance knowledge.
Yeah, I think we see this quite clear distinction at the international level between sort of research, which is generally viewed a bit more favorably than sort of other deployment type activities. And it sounds like, Alexander, that that's sort of been translated into German law, but is not necessarily present, at least in US law, a clear distinction. So that maybe brings me to another question, which is, in Germany, we have seen this legal action to specifically address these marine geoengineering activities. We haven't yet seen that in China and the US. Assuming we don't see that in sort of the short term, are there sort of other things that we should be looking at in terms of sort of domestic governance of ocean CDR activities? Is there things that the research community itself can do in this space to enhance governance, for example, through the development of codes of conduct or other things? Do any of our panelists want to weigh in on sort of the value of that?
Okay, I just say a few words about the MSR, the marine scientific research, because this is also very important area in the law of the sea studies. And in China, just as Lei mentioned, that there was a regulation called the regulations governing the foreign-related marine scientific research. That means that if a foreigner or a foreign scientific institution wants to conduct a scientific research within China's jurisdictional waters, it must submit a kind of application for approval by the competent authorities of China. That is maybe six months prior to the undertaking. So this is, but now because of what is the marine scientific research? So this is kind of a definitional problem, still subject to kind of discussions in the law of the sea studies, and for between China and United States, and for the military surveys, like the military surveys, military intelligence gatherings, and some kind of controversies between China and United States. According to China, some kind of military activities, they should be subject to the regulations of China in terms of marine scientific research. But the United States says that these are the military operations, not subject to the marine MSR governance, the legal regime under the UNCLOS. So there's a kind of controversial debate between the two countries. So to me, and at a domestic level, and China has a law to promote the scientific research. and also technological development. And China also has some other promotional policies to conduct scientific research in the coastal areas. And for the ocean CDR, and because some of them are just at the experimental stage, and which conducted usually by scientific institutions like the Chinese Academy of Sciences, and also some prestigious universities, which has specific colleges or oceans. So like the Zhejiang University, just mentioned by Dr. Zhang, and all these so mainly speaking that at the current stage for the 5 ocean CDRs, and they are still at the experimental stage in China. Thank you.
Thank you. We've had a few questions about the application of US law, of domestic law, sorry, beyond sort of EEZs on the high seas. Can you each just say a few words about when and how your domestic laws might apply to activities on the high seas? Alexander, you want to start?
Well, once again, I'm now basing my statement on the High Seas Dumping Act, which actually defines where it is applicable outside of the German EEZ, and of course also outside of the territorial sea. That is, on the high seas, with regard to German flagged ships, obviously because of the principle of flag state jurisdiction, it is not possible for Germany to regulate the conduct and board of foreign ships. That would be a sovereignty issue. Secondly, on platforms that are German owned, at least co-German owned, and then even in, as I said before, even within maritime zones of other states with regard to activities conducted by German ships, which means that such activities would then fall within the jurisdiction of 2 states, namely Germany as the flag state of the ship, and secondly, the coastal state whose EEZ is affected by the experiment concerned. So that would be my answer.
Great, thank you. Korey.
Yeah, I touched on this briefly in the presentation, but maybe it caused a little bit of confusion. So worth clarifying that the MPRSA has 3 hooks, any of which is sufficient to engage EPA permitting processes. One is if the materials were transported from within the US, and this is regardless of where the dumping occurs. So this can be in the high seas. One is if you have the use of a US vessel, similar to Germany, if it's a US flagged ship, regardless of where the dumping occurs. And then if the materials are transported from elsewhere using a different country's flagship, then you get that within the 12 nautical miles of the US, the MPRSA applies as well. So for the dumping of materials, there's quite a few hooks that the US law brings in.
Yeah, and there can also be some application of US law on the high seas, particularly around some of the species protection laws can apply on the high seas. So it is the Marine Mammal Protection Act and the Endangered Species Act, for example, both prohibit what's called the take, which includes the killing of certain species on the high seas by US nationals. So there can be some additional application of domestic law on the high seas. What about in China? When does sort of Chinese domestic law apply on the high seas? Oh, I think you're muted.
Okay. Thank you. For the high seas jurisdiction, China takes the flag state jurisdiction in general. And so that means China only regulates its own vessels on the high seas. And but there's no other specific regulations governing the high seas other vessels on the high seas. However, there are some bilateral agreements or multilateral agreements existing in the Chinese legal framework, stating that, for example, the fisheries management in the North Pacific, and China and the United States, they have a bilateral agreement on the mutual inspection on the vessels, on the fishing vessels in the designated areas in the North Pacific. And also China unilaterally, recently years, China unilaterally declared some crude seasons on the high seas, close to the in the southern Pacific, close to Chile and Peru, and banning the Chinese fishing vessels for squid on these areas. So this is kind of only governing the Chinese fishing vessels, not the other fishing vessels. So this guy. So in terms of, and China also pioneer investor registered under the International Seabed Authority. So recently China adopted a law on the deep seabed mining, and this is also governs the Chinese nationals and China companies, their operations on the seabed.
Great, thank you. One additional question in the chat for Alexander is around, Germany has this really more established regime than other countries, and quite a strict regime, as we've talked about. To what extent are the German regulations shared with or similar to those of other EU states? And can you just say a few words about sort of the EU situation here?
Yeah, thanks. Well, there's no uniform EU legal situation. That has to do with the division of powers between the European Union on the one hand and the member states on the other. Now, to my knowledge, it is only the United Kingdom, if I'm not mistaken, which has accepted the 2013 amendments to the London Protocol. But correct me if I'm wrong here, but I'm not aware of whether they have actually implemented and in what way this amendment into their national law. I assume not, simply because the international regulations have not yet entered into force. So there is no joint approach concerning the regulation within the EU, not at all.
Great, thank you. All right, we have about 2 minutes left, so I'm going to just ask our panelists to just give a couple of final remarks. Any additional points you wanted to raise? Anything that you can say about sort of, I'd be interested to hear your perspectives on comparisons between the different ocean CDR approaches. Are some legally easier to pursue than others, or the legal opportunities are greater for some than others, or anything else you want to close with? Korey, why don't we start with you?
Yeah, I think that first thing that comes to mind is that the US is party to the London Convention, but not the London Protocol. And that potentially opens up some opportunities for companies to conduct research and potentially deployment down the line that might not be available in London Protocol countries, but not necessarily. But also that the US environmental legal framework is strong and will still apply to quite a few of these activities. So that's not to say that in the US there's a free pass to conduct these experiments without any checks. But like as I laid out in the presentation, I think there's quite a few overlapping jurisdictions and permitting processes that you'd have to go through. So coordination and developing a legal framework might be especially helpful, especially with these tens of millions of dollars injected into the research landscape in the past couple of years.
Anna, a few final remarks from you guys.
Okay, I just add one point. Just Alexander mentioned artificial reefs, and commonly known in China is artificial reefs because it is related to dumping, whether it is related to dumping. And in China, it seems to me that the reef restoration and the artificial reefs are regarded as planting rather than dumping. So that is maybe it cannot be categorized as kind of dumping.
Thank you. Alexander, final remarks.
Thank you. Excuse me. I mean, that's just an interesting point that Keyuan just mentioned. And it's also that, there were a couple of questions also in the chat concerning this divide whether there is one actually, between ocean CDR on the one hand and nature conservation on the other. And that is also a matter that is quite tricky with regard to the interpretation of the German Act. Now, my personal line of argument would really be activities that are in line with nature conservation and that, first and foremost aim at conserving a certain part of nature could easily be, qualified as such nature conservation measures, but others could not. But I mean, there's obviously a lot of need for discussion on that very matter. And I do not have any kind of final answer on that. That's a very specific point, maybe not the most eligible one for a concluding remark, but I just think that this is one of the issues that we really need to deal with in legal thinking. Thanks for that.
Yeah, there is certainly plenty of work left to do and plenty of questions still to answer. So I want to thank all of our panelists so much for really interesting presentations and a great discussion. I think we all learned a lot. And I'll turn it back to Will.
Great. Thank you. So
for moderation.
Okay. Thank you so much, Romany, and thank you to all the panelists again. I thought it was great. I mean, I think one thing that's really striking and a bit of a precautionary tale for developers of these approaches is the fact that Germany, as Alexander pointed out, is one of the few places where there actually has been some active interventions in terms of these approaches, and the government response was pretty stringent, right? On the other hand, I think the fact that in many places where these things might be used, the fact that there's a lot of ambiguity also creates a lot of uncertainty for those that might engage in the experiments, those that might seek to invest in these. And maybe it's good that Germany is providing at least one kind of model of what specific regulations would look like in this context. It'll be interesting to see if places like China and the United States, as this research begins to broaden and deepen, which it sounds like it may, especially in the US with all of the potential funding that's coming forward, whether there'll be development of dedicated frameworks in the context of carbon removal that could in some ways limit carbon removal in ways that may be advantageous in terms of protecting other interests, but also might help facilitate it by providing more certainty. So it'll be interesting to see. And I thought this provided a great framing for that. So thanks to everyone, including the audience members, for your questions. We will now adjourn until 1 p.m. Eastern time. Please come back for our next panel. It should be very interesting. It's moderated by the head of the World Oceans Council, which has been actively engaging its members, which includes many members of the maritime industry, in the potential role of carbon removal in those industries and the impact that it might have on those industries. And there'll be a number of experts, and there'll be a number of project developers of carbon removal approaches that will be part of that panel also. So we'll come back at 1 p.m. Eastern, and thank you, everyone. See you then.